is what is important. If there is a respondent, the respondent is the accused. The other person is the aggrieved complainant, is the aggrieved woman. And once you have corrected this, then your proceedings start. Now, how do you start the proceedings? Necessarily, you need to ask the accused person whether he has received the complaint dated service. If he says no, ensure that the complaint is given. After that, you ask him this question: have you read and understood the contents of the complaint? When he says yes, you know that he is aware of what he is facing. Explain this to him and say that the complaint, if proved, will constitute misconduct under, or sexual harassment under the Sexual Harassment Act. And once having stated that, you ask him whether he pleads guilty or he does not plead guilty. Now, these are the essential formalities to say that you are giving him a reasonable opportunity to proceed his case, to defend himself. Once he says that I am not guilty, one of the basic things that you have to do is tell the complainant that it is up to her now to prove the case against the accused. Now, how does she prove? She can start with her own complaint, read it out, or narrate the whole thing, whole incident, and say, this incident I have complained against, and my complaint is dated so and so. My complaint may be taken on the records of the complainant's committee as a document. So the document of the complainant is introduced there to state the complainant's case. Right? Once the complainant does that, the complainant is subjected to questioning. I am not saying cross-examination, questioning by the accused person, who comes and tries to say that that incident did not take place at all, or it took place, it had some other connotation, he didn't intend whatever he wants to say. All that will come through questions or through documents to his evidence. Now, thereafter, the complainant can be asked if she has any witness to substantiate her complaint. If there is a witness available, she can say witness is there. If there are no witnesses, then you can say my case rests with my statement. If there are witnesses, the witness will have to be examined in the presence of the accused, and the accused will have to be given an opportunity to cross-examine. This goes on. If you have got 10 witnesses, one after the other come. If there are only 3-4 witnesses, then the whole thing comes to it after 3 or 4 witnesses. After examining the witnesses of the complainant, you make a notation there saying that the complainant has no further witnesses to examine. Once that is done, then you ask the accused person, to the respondent here, to produce his witnesses if he wants to. Naturally, he will produce the witnesses, the processes will be reversed, and after he examines his witnesses, the complainant will be given an opportunity to cross-examine the witnesses. It goes on serially, like one witness, second witness, third witness, fourth witness, and then at the end of that evidence, you say that the complainants, the accused also has no further witnesses. Then what happens?
The statements need to be recorded?
You have to record.
Examination in chief and cross-examination.
You can say examination in chief or questions asked. Which one?
Are the parties who are deposing supposed to initial these statements that are getting recorded?
So therefore,
So,
after each page of such recording,
what if the witness does not agree to come?
once, let me complete this. After recording the witnesses, page by page, at the end of each page, you take the initials of all those people who are present there, and at the last page, you take their signatures in token of having completed the day's proceedings. You record that today's proceedings are over, the proceedings will be resumed now on so and so. Right? Because your question was that if witness does not come, Okay.
What if they don't agree that,
The Act says that the committee has the right to summon witnesses. So you can summon witnesses. The witnesses comes and does not depose, keeps his mouth shut. You can draw an adverse inference. In other words, if it is a witness on the part of the accused will lose. If it is a witness on the part of the complainant, then the questions not answered will go in the favor of the accused, right? So this procedure is inviolable in the sense that what you are doing is you are trying to give a reasonable opportunity to the accused to defend himself, further also to state his own case in the manner that he thinks fit and through his witnesses. There is no particular order in which these witnesses should be produced. You can produce any witness that would suit your argument or your convenience at any time. So this is the general procedure. Now, similarly, documents. What is a document? Document is any written record, any marked thing is what is known as document, and those documents will also have to be produced during the inquiry if you are depending on those documents. If you are not depending on those documents, it's all right. But if you are depending on any of these documents, then you will necessarily have to produce these documents through the witnesses. It is not just straight away producing it before the committee. The committee has a right to not to mark the document, but in evidence, in the sequence of evidence, if a document is required, that document can be produced in the inquiry proceedings. So I will take very difficult things.
Question. How would this scenario play out if the accused is somebody in power, authority, or gunda? Then you can't have the witnesses in front of you.
Absolutely, absolutely. That's why I said that this is a special enactment. And the case that I narrated showed that no witnesses were examined in the presence of those students. This is exactly that judgment. If you permit, I would just only say this. There was no question about the incident. The only question was of identity. And therefore, no question of cross-examination and all that. And then they say that we know of statutes in India like the Gundas Act, which permit evidence being collected behind the back of the Gunda, and the Gunda being merely asked to represent again against the main charges arising out of the evidence collected. So the flexibility that this law will rest on the committee to decide is something that is very important, and that is where this examination and cross-examination comes. And I actually want to take you through some 14 or 15 questions that would come up during the internal committee hearing. There are important points for internal committee. What are the points to be noted by you? Don't cross-examine the accused before leading aggrieved employees' evidence. Do not ask the accused to produce his witnesses first. This is because it is on the accuser to prove his case, and it is not on the respondent to say that I am not guilty. Where you explain questions in vernacular and record in English, no prejudice is caused to the accused, especially when she does not produce or he does not produce. There must be some evidence to show that the statements recorded in English were explained in vernacular to the accused. The records must show in what order and on whose behalf the various witnesses were examined serially, one after the other. Therefore, you say witness of the accused students, and then examine all the accused witnesses. Similarly, the respondent's witnesses, you examine all of them at one go, and immediately after the evidence of one witness is over, permit cross-examination. Records must show in what order and on whose behalf the various witnesses were examined serially, one after the other. Recording of evidence should not be delegated. You are all very busy people, especially my chief executive here. So he will say, you talk and conduct the lecture, I am going and taking some rest. Not allowed. But I am going and, attending to some other job. In the meanwhile, your operator keys in whatever the other man says, not allowed. And this is precisely what happened in the Banking Committee's award, Banking Commission's award. Justice Sen was in charge of the commission, and the inquiry went on into the wages and other service conditions. And there were 3 members, 2 members regularly attended. One man flitted in and out because he was settling very high finance between partition, during partition time, what assets belong to India and what assets should go to Pakistan. He was deciding on that. So he didn't attend the commission's proceedings. And only on that ground, a very, very good award was set aside by saying that he has no right to come and sign that award if he has not attended the proceedings. So therefore, you must ensure that you sit through the proceedings. Don't delegate recording of evidence can be in question answer form, or it can be recorded only in answers. Then you don't record aside discussions. That could happen. People start arguing and fighting amongst themselves. You don't have to record all that. If there is any important question, you can record that in question answer. As the deposition goes on, there could be very important questions. And that you should record in question answer form, especially if the parties want. Then internal committee has to find out the truth. Therefore, the committee can also ask questions. You are not dumbos there, You are very intelligent people. All the intelligence you are displaying here, by God, display there on the committee. Then, though you are appointed under the Act as member and presiding officer, etc., when the witness comes in, you have no right to administer oath because you are not in court. At best, your proceedings can be termed as a quasi-judicial proceedings, and it cannot be termed as a judicial proceedings. So you have no right to administer oath. When one witness deposes, this is very important, and I forgot to mention it. When one witness deposes, see that the other witnesses are not there. All depositions should be taken by singular witnesses. All the others should be kept out. They should not hear as to what is happening inside. Leading questions. Well, if it is a question of fact which has been established, we can ask those leading questions. Otherwise, we cannot even ask leading questions. Now, how this whole thing will develop, what shape it will take, I cannot tell you, but I can only narrate 2 or 3 cases which I am sure you will remember when you are reading this case. One is the case of meritorious crime. A young girl used to pass by the branch every day. She was studying in 8th standard or something like that. For years she walked by, saw the manager sitting in the glass cabin, waved out her hand. This old man also waved out. The old people have got the habit of making their presence felt in this young girls. Years passed. I am not speaking of experience. Somebody else Years passed. The girl had passed, did her graduation. She came and asked the manager, what do you think? Do you think I can get a job in your bank? He said, of course you can. I've seen you day in, day out. You're studying well, good girl. And he happened to look like a very fatherly figure. She went and joined as a teller, carried on for 4 years, and there were no complaints, everything was fine. And one day, the old man invited her for lunch. He said, today I have not brought my dabba. Can we go out and eat? She said, oh, it's fine. After all, good man, given her a job, fatherly figure. They went out for lunch, and then he proposed sex. And she said, look, you want? And then she thought that she will do some job. She had sex with him. That went on for 3 or 4 years. Till she met her boyfriend. And then said, enough is enough, I need to stop this. Now, what happened was, before the court, the argument that took place was that this was consensual sex. All that had happened for 4 years was consensual sex. And the court said, you are looking at the section lopsided. The section says, it doesn't speak of consensual sex. It speaks of something else. It says unwelcome conduct or behavior. Right? That's what Professor Saab said. Unwelcome conduct or behavior. Unwelcome conduct or unwelcome behavior. That's how it should be read. And if she had protested, the court said that is unwelcome conduct, and you should look into this, what shall I say, conduct under this enactment, under the unwelcome, not on consensual aspect. Consensual aspect has nothing to do with it. If unwelcome conduct is not there, consensual act will be a good defense, not necessary. Number two is another case where the manager requested the secretary of the chairman to come to the business center of Taj and said that chairman wants to give education. So we chairman, especially, they speak in high-flown English and all that. The secretaries are incompetent to take down some of the words. And necessarily she needed help. So his manager said, I'll come sit with you, help you, so that you can crack on your typewriter. So both of them went out, she started typing, and this man in the text of helping her started touching her inappropriately. And she objected, saying this is no problem. Now what happened was in that particular case, the defense raised was, at best, what did I do? I tried to touch. No, this is what the evidence spoke of. And then they said, where is the witness for all this? Okay. The Supreme Court of India Supreme Court of India said that, look, mere attempt to touch itself is a misconduct offence. That is one reason I have said working place is no more fun. Experiences. You can imagine what happens here is that mere attempt to touch, they said, is a sexual harassment case, and there need not be repeated offences. No dictionary meaning of harassment suggests repeated offences. In this case, there is no requirement of repeated offences, and all that you need to do is some evidence to hang this man. And what is the evidence? After the dictation episode was over, this girl went to the office and she started beating the witness. So one of the co-employees, another lady, came and asked her, what's wrong with you? Are you not well? She said, no, I can't tell you this, terrible thing happened with her. And I'm an unmarried girl, how do I relate on this? The Supreme Court said that this is evidence. Do you follow? From where principles of natural justice, that strictness goes away when it comes to sexual harassment cases. There is a lot to evolve on this. But this is a very, very serious business. And that can be tested. Or by the third case, which I narrate and then say thank you. The third case again is a case where a secretary working in in the Saudi Arabian Airlines. Her time for promotion came, she was overlooked, and when she complained to the boss, he said that, look, you want promotion, come to my house at 11 o'clock night and we will discuss the details. She said this is nonsense. He pressurized her, come for lunch, come for dinner, come for this, come for that. She withstood all the pressures. And one day she took courage and went and complained to that chap's boss. And the boss said, this is a stupid fellow, you come with me. She applied for leave was not granted, she was sacked. And then the court went into the whole issue. And then they said that this is not on her evidence is good enough because a junior has been promoted, she has been sacked, and the reason is crystal clear. Now, in your lifetime, you come across many, many such situations. Interesting, some, and others pain. But then, there would have been enough development in the area by that time. And and I'm sure you will come to appropriate conclusions. And that part of the appropriate conclusions, I am saying it to my friend Mr. Gowda, that is the most difficult portion. Thank you very much.
Also, I must say that you have kept to the time. So he did call me that I am the headmaster. But you know, I have a role to perform. And if I have a role to perform, I have also to manage the time.
And he kept the students awake.
And he kept the students awake. And he said that, you know, the amount he'll make you laugh, nobody else will make you laugh. So that's the other credit to him. He's an excellent speaker. And what he has done is he went through the process in terms of how the domestic inquiry needs to be conducted. Because all said and done, the inquiry can be challenged later in a court of law. And that's what comes up. And one needs to be careful in the way one does it. The next speaker is C.K.D. Gowda, who is going to explain, as the Krishnamurti put the tougher part on the findings and writing of the inquiry proceedings. He has worked